Are you interested in how the recent Supreme Court ruling and subsequent EPA changes to wetlands permitting regulations affects your development project? Let's dive into that. So this past year, the Supreme Court ended up ruling in a court case that involved a defendant from Idaho that the Clean Water Act, which has been a law in existence and approved in 1972 and has had decades of precedence through court cases and all sorts of things throughout the years. They decided, this particular Supreme Court, that the rule that has been in place since the beginning, that wetlands, the broader definition of what a wetland is, doesn't apply, and that really the regulators have taken too much advantage of that law. And really the way that the law was written in 1972 was strictly to regulate waters of the US that are connected to navigable waterways. And so this has a sort of a dual connection. It largely started around commerce. If you can think of, the fact that ships and boats and things like that need to get up and down riverways and canals and rivers and lakes around the United States to move products, move materials around. And that's really big money. So that's part of the reason that the Clean Water Act and the previous acts before it really served to regulate these waterways from a commerce perspective. But in 1972, when the Clean Water Act was passed, it had this larger environmental focus as well of protecting the world, protecting the environment. And so this Supreme Court now has decided that the broader definition of a wetlands, which could potentially, if you think about it, water is capable of going through a lot of different materials, including earth. So what they're saying is that if there is no surface connection that you can see on the surface of the ground, that water, if it's a wetland and there is no connection to another waterway that is ultimately connected to a navigable waterway, if there isn't that connection, then it isn't a wetland or an other water of the United States. And therefore, you would not need a permit to impact or remove that wetland. And so that has a big implication, because the amount of water that they're talking about across the United States that could potentially be removed is about the size of the state of California. That's huge. So, from a developer standpoint, this would potentially be a good thing, that you don't need these, sometimes people think of these as very onerous permits. You don't need this big onerous wetlands permit in order to go and build that development on your property, because those waterways and wetlands that are there are not connected to any other navigable waterway, and your job is easier. So that's the bright side of the opinion, or the ruling from the Supreme Court, which ultimately ended up in the EPA revising their rules. So now when we submit a wetlands permit application to the Army Corps, we can tell them, well, here are these wetlands over here, but they're isolated. They're not connected to any waterway. Therefore, they're not part of your jurisdiction. And therefore, we don't feel that we need a permit for that. The other side of the coin, though, is that there are two complications with this issue. Now, and this is aside from the fact that if you're an environmentalist and you're thinking about the fact that these developments ultimately take away water storage across the United States, that really could potentially result in larger flooding and other issues for local communities. Aside from that larger conversation, let's just talk about the development for a second. So what does this decision mean in terms of a developer actually being able to get their development approved and developed? Well, there's two potential issues or complications around this. One is that the United States Army Corps of Engineers has to consult with other federal agencies if there is a potential for affecting something that is regulated by another federal act. So, and there are two specific consultations that they have to do on a project if there is that potential for effect. One of them is for endangered species. So if the Federal Endangered Species Act that is regulated by the U.S. Fish and Wildlife Service, they have a list of federally threatened and endangered species that are protected. And you would need to get a permit, an incidental take permit, in order to affect those species. So when you have these wetlands on properties, a lot of times endangered species are associated with wetted areas, and for good reason, because people have been removing wetted areas for a very long time. Well, if your wetted areas on your property have the potential for containing endangered species that are protected by the Federal Endangered Species Act, then if you go in and you apply for a wetlands permit to remove those wetlands, the Army Corps of Engineers has to consult with the U.S. Fish and Wildlife Service as well about removing the species that would be contained in those wetlands. And the ultimate permit that you would get from the Army Corps of Engineers would include what's called a biological opinion from the U.S. Fish and Wildlife Service that says that if you affect these species, that you will likely have to pay some sort of mitigation or something along those lines. Well, that is all on a time track. There are specific requirements and regulations for those agencies to get those things done in a certain period of time. And so that means that you, when you submit a permit, potentially the idea is be assured that at some point that you would get a permit for removing those wetlands and the associated federally listed species that are also potentially there if you have that kind of an issue. Well, if there's no wetlands to permit on the property, then you have to go directly to the U.S. Fish and Wildlife Service to get that incidental take permit. And unfortunately, that is a much longer timeline because they don't have actually a time limit in their regulations for how soon they need to get back to you on that application. So, in practice, we have seen those individual incidental take permits that people apply to the U.S. Fish and Wildlife Service for taking upwards of 10 years, 15 years. And there is a question of whether you would ever get it at all. So it definitely clouds sometimes if you have a potential for federally listed species on your property, then it could potentially cloud the amount of time that it would take you to ultimately get approvals to develop. The other issue is that regardless of whether or not they are jurisdictional under the Federal Clean Water Act and regulated by the Army Corps of Engineers, a lot of states also have laws in place that protect those wetlands if the federal government doesn't protect them. They would, in that case, be called waters of the state instead of waters of the United States. So in that case, then you would have to apply to that particular state. Like we're in the state of California, we would have to apply to the State Water Resources Control Board for a permit to remove those wetlands. So essentially, it doesn't really reduce a whole lot of permitting if you're in a state that also would require a permit. But if you're in a state like Texas or Tennessee that is much more lax on federal regulations and state regulations, then you may not have to get a permit at all. So it really kind of depends on the situation. If you need help guiding your project through the complicated permitting process, if you have wetlands or other environmental resources on your property that could be an issue, give us a call. We can definitely take a look and see what we can do. Or, what are those regulations that you really need to follow there? And how can you get your project? For more environmental advice, visit our website at coxplanningsolutions.com. And don't forget to follow us on YouTube and LinkedIn.